very pleased to be here at the Peace Islands Institute. I think we all hope that Peace Islands will soon become peace continents, but we don't live in that world yet, have that ambition. I face a slight difficulty, as you can see from the outline that's in front of you. My talk very much agrees with what you've just heard from Ambassador Schapper, so I'll try not to repeat any of the points that he made so persuasively. The essence of much of what I wanted to say he has just said. I will talk around some of the points, adding some new elements to it. What I'd like to stress is, again, the theme that R2P is special. It's a landmark development in the international normative structure of collective security. That is, the collective security not just of states, but of people, collective human security. And it's therefore, I agree, very much worth defending. I think its essence, you'll see in the handout I have in front of you in those two paragraphs, is a license and a leash. It's a license to use pressure if countries fail to protect their own people for certain measures that go beyond the standard international legal provisions that we see in the UN Charter. So it allows more than a simple reading of the Charter or traditional customary international law would allow for the use of residual pressure if governments fail to protect their own people. But equally importantly, it's a leash. That is, it restricts the use of pressure and force among states in very, very important ways to the four key elements that Professor Schapper mentioned: war crimes, crimes against humanity, ethnic cleansing, genocide, and restricts to the Security Council. That's the essence of this doctrine. And we wouldn't have one without the other. And we have to understand that combination as a license and a leash. And that's what I think the essence of the R2P revolution is. What I'd like to do in my minutes here is to make a few remarks about the law, how it stands and why this is a new development. Number two, about the evolution of the legitimacy of the R2P doctrine. R2P is not law, it's a normative doctrine. Where it came from. A couple of comments about practice before Libya. I'll mention something about Myanmar, Kenya, and Guinea very briefly. And then some last concluding remarks on Libya and Syria. So I'll say very little about that because what Ambassador Schapper just said strikes me as exactly a description of the great difficulty we now face. That is, we have this very important tool, but it's not being used, and powers are now trying to work around it in ways that might be dangerous. Let's turn first of all to the law. International law is wonderfully contradictory, I would suggest to you. Article 2.4 of the Charter prohibits the use of force against the territorial integrity or the political independence of any state. Article 51 makes an exception for self-defense, individual and collective. That is, you can defend yourself. So you can use force as a state unilaterally only if you've been invited to do so by the state. So through invitation, a state can invite foreign assistance, including military assistance, or you can use force if you have been attacked individually or collectively, as states came to the assistance, for example, of Kuwait in 1991 when it was attacked by Iraq. The only other exception to that in the Charter framework is through Article 39, the Chapter 7 powers of the Security Council, where there's a very broad gift or donation of authorization to the Security Council to use force not just in self-defense, but for the prevention, for the dealing with threats to the peace, breaches of the peace, acts of aggression. There's a very wide license given to the Security Council. So you can use force if invited, in self-defense, or with the authorization of the Security Council. So it seems quite narrow. On the other hand, in the international law community, we know that one of the deepest norms, called the jus cogens, because it's so compelling, is the norm about genocide. And in the Genocide Treaty, all states have pledged to prevent, stop, and punish the crime of genocide. Genocide occurs within a state's borders, which are otherwise protected as domestic issues, but that's been declared to be a deep, fundamental rule of international law. So we have a broadening there with the Genocide Treaty. And secondly, we know that through the practice, the phrasings in Article 39 give a nearly unlimited, huge realm of discretion to the Security Council to determine what, in its view, constitutes threats to international peace and security. And so during the 1990s, the Security Council authorized interventions in Haiti, for example, in 1994, in order to restore a democratic government that had been overthrown. There's nothing in the charter about allowing interventions to restore democracy. But nonetheless, the Security Council did that. They then find an international rationale for that. But who thinks that the state of Florida was threatened by desperate Haitians showing up in leaky boats? That's not very plausible. The real reason was humanitarian, was the restoration of democracy, was the sense that the Americas thought that this was a legitimate thing to do. So the Council operates with very little constraint. This was once appealed by Libya to the International Court of Justice in a famous case in Libya. The International Court of Justice also stated that it would not review Security Council decisions taken under Chapter 7, affirming the license that's been given to the Security Council to decide whatever in its own view is constituted by international peace and security. So on the one hand, we have in the Charter a limitation on the use of force, self-defense or invitation, and a guarantee of domestic jurisdiction of states. And then on the other hand, we have very powerful norms like genocide and the huge discretion that's been granted to the Security Council, which in the 1990s it used for all sorts of purposes: humanitarian, local and regional security, democracy, as I mentioned, in Haiti and elsewhere, with no ability, at least asserted by the International Court of Justice, to challenge that. So that's the state. Let's now turn to legitimacy. Ambassador Schapper mentioned that the origins of this responsibility to protect idea go back to the travesties, the horrible tragedies that took place in Rwanda and in Bosnia in the 1990s. It was focused for the international community in the events in Kosovo in 1999, where, in the words of a commission that looked into it afterwards, the Goldstone Commission, chaired by Mr. Goldstone of South Africa, that what took place there was illegal because it was not an act of self-defense on the part of NATO, and there was no invitation from Serbia, needless to say, and there was no authorization from the Security Council because Russia was not prepared to allow that. Illegal, but legitimate. That is, in the view of the commission that looked into it afterwards, legitimate because the Kosovars were facing extreme threats, not only of casualties being suffered, but of a massive ethnic expulsion that the government of Milosevic looked as if it was planning and had already engaged in part in Kosovo. And so the commission then went on to say, when can force be used in these circumstances without a Security Council authorization? And it said, and I quote, when there are severe violations of human rights or humanitarian law, and there's a failure of the state. It sounds okay, but that's incredibly broad and indistinct. Do we want to have that as the trigger, the legitimate trigger, and say to any state, when you have a firm, well-reasoned view that there are severe violations of human rights, you can use force across borders? One can imagine that produced a great deal of pushback. The pushback was quite fierce. The group of 77 condemned the idea of humanitarian intervention in their ministerial declaration of September of 1999. So here we have some of the international community, NATO, saying this is legitimate, and a very large hunk of the rest of the international community, at least through the voice of the G77, condemning it overwhelmingly. It was this that inspired Secretary General Annan to, with the support, needless to say, the strong and important support of the government of Canada, to form the International Commission on Intervention and State Sovereignty under the very important chairmanship of Mohammed Saknoun and Gareth Evans. And they then did a very thorough investigation of this question with a group of eminent commissioners, debated it at great length. And they decided to come up with a slightly different, but importantly different standard for when force can be used for humanitarian purposes. And that's only when there's a large-scale loss of life, and I'm quoting, not just human rights violations. When a state is failing to stop it through inaction or action, okay? And the Security Council, they went on to note in their report, is the right authority, but then they left open the door saying it's not the only authority. And if the Security Council doesn't act, someone else will. And that's embedded right there in the Sutton-Evans report. This was then presented to the Secretary General in the spring of 2001. This was the report. There was a lunch which was presented. I was then working for the Secretary General. He turned to me and said, Michael, please arrange a room here in the UN where the commissioners could present this report so that it could be discussed with the membership fully. I then went to the chef de cabinet, to the then president of the General Assembly, Minister Han from South Korea. The chef de cabinet at the time was Mr. Ban Ki-moon. And I approached Mr. Ban Ki-moon saying, can we get a room? And within less than an hour or so, he called me back and said, no way. This was way too controversial to be discussed within the UN framework. It went across the hotel, to the hotel across the street, then called the UN Plaza. They've changed their name a couple times since. The report was presented there, very actively debated. But there wasn't enough sentiment in the UN to adopt this report in any broad, meaningful sense in 2001. The Security Council then, as it did, had its annual retreat at Bocantico a month or so later. And the council met, and the theme was R2P. And Evans and Sahnoon presented the report at this confidential meeting of the Security Council. It's 15 years now, so I think I can talk about it without being prosecuted. There was a very extensive discussion. And unusually for the Security Council, they were perfectly unanimous. Okay? They came down exactly on the same page. What happened is they decided that R2P was something that was within the purview of the discretion of the Security Council. That is, they could take this and act upon its basis. And every state agreed upon that. By the way, Syria was a member of the council at that time, and the Syrian PR had to cable home to get confirmation from Damascus, and he got it. It came back. So they all agreed that R2P was within the purview of the Security Council. But they also unanimously agreed that they had no obligation to do anything. So on the one hand, they said they had the right to act on the basis of R2P, but they were not willing to enunciate as a matter of public principle that they felt that they were, let's call it morally or normatively obligated to do something. And that's been the state of R2P. That's where the doctrine was. So it then took 4 more years of really excellent diplomatic work by Evans and Sutton and their colleagues to persuade the international community that this should be embodied in the 2005 summit document, where it was negotiated amongst the members. You have the 2 paragraphs in front of you. So what happened to make that possible? The first thing that happened is, as Ambassador Schapper mentioned, they narrowed down the triggers for the use of coercive force and responsibility that would be enforced internationally, if necessary, if needed, to those 4. War crimes, crimes against humanity, genocide, ethnic cleansing. Not broad human rights violations, not just large losses of life, but those 4 elements of the, call it the case for R2P. If you look at the handout I outlined, as if the international community was hard of hearing, they repeated it 5 times in those paragraphs so that everybody got the message. Only these 4, not others. And the other important element of it, that therefore was the license saying to the community and the council, the membership is now saying that the council can protect individuals, if necessary, for those 4 harms that could be done to them. That's the license. The leash is none of this unilateral action. No Security Council first and something else, but the exclusive purview is attached to the Security Council to authorize coercive measures, if necessary, if a member state fails to protect its own population and assistance doesn't allow it to do so. So that's where this doctrine took. I don't want to use too much more time. Let me just briefly mention the practice following that, because that was quite important. In May of 2008, a cyclone, Kargus, hit Myanmar and had devastating effects across the country. The then SLORC, the military government of Myanmar, was not adequately assisting its population. That is, that there were reliable reports circulating that many people were subject to waterborne diseases, they were not getting adequate food. This was a serious emergency. So a number of international commentators then said, this is an R2P situation, okay? Because we see all these people suffering. But there was immediate pushback, including from the UN, the Secretary General, and in the Security Council, that this was not really an R2P. This was horrible and assistance needed to go, but this was not the circumstance that would justify R2P pressure on the government of Myanmar, even though they were slow in getting assistance to their own population. And the reason being is that what was happening there was not a crime against humanity. In the law, to have a crime against humanity, there must be a systematic pattern of abuses that reflect planning, what they call a mens rea, an intention on the part of the government, and there was no proof of that. And so the Secretary General, the UN community backed off and said, no, this is not R2P. And why is that important, the not acting in this case? Please remember, eventually, with the very good assistance of Singapore, measures were taken to organize assistance. But nonetheless, people suffered. So the reason it was important, this assured, especially the sovereignty-sensitive countries, that R2P would really operate the way it was supposed to operate. And this built some of its legitimacy. In the next two cases, in Kenya and in Guinea, R2P was significant in the Kenyan case in the background. Kofi Annan, my former boss, told me after he came back from the Kenya mediations that he never used the word R2P with the parties in Kenya, never. But he very well knew, and other African states were using the word via the government, that the government and the opposition knew that in the background, if adequate action was not taken to protect the citizens who were suffering greatly in Kenya in the course of this election-related violence, in the background was the possibility of coercive measures if Kenya failed to step forward. And the Kofi Annan said that was quite important in the negotiations. It provided that background big stick that never had to be pulled from behind your back, that was available to persuade the parties that this would not operate totally without the attention of the international community if things got worse and worse and worse. In Guinea, the words were used and was helpful in producing the transition to a legitimate civilian government and stopping some of the abuses that occurred there in 2009. So we come to Libya, and I won't repeat what Ambassador Schaffer has just said. The Security Council resolutions 1970 and 1973 were very important. These were the second and third times that coercive measures under Chapter 7 were authorized with specific reference to R2P. Truly important in the measures behind that was, of course, the support of the Arab League. This regional endorsement was quite influential, I've been told, for China, maybe also for Russia, in producing their abstentions and not vetoes. One could well make an argument that it avoided regional escalation. One can make an argument as well that there were a pattern of war crimes that were increasingly well known and pretty well documented taking place. As President Obama said, there was a danger of a massacre in Benghazi that pushed forward action on the part of NATO and put pressure on to get the resolution to come through. In the end, of course, it did fall, the resolution did go through, but as we know, it had one very good purpose, that is, it certainly helped the Libyans to survive, which otherwise would not have been the case. That is, if they faced Gaddafi's forces alone, they were not standing up to them, they were being destroyed. The other side, of course, is it toppled Gaddafi's government. Many think that that was a necessary logical outcome given the radical loss of support that his government had experienced. That is, the vast majority of the Libyan people had turned against him. But there has been some buyer's remorse on the part of some countries who see this as a move towards a new regime of regime change authorized by the UN. And there have been complaints, some coming from Russia, some coming from China, that that's not what they thought that they agreed to. They thought they agreed to pressure, a no-fly zone, and then negotiations would settle the future. That they would only be protection at the spot, not an overall air campaign against Libya. Ambassador Rice says that she carefully briefed her colleagues in the Security Council saying there was no way they could do spot-to-spot protection. NATO could do spot-to-spot protection of the Libyans. If there was going to be a no-fly zone and NATO aircraft over Libya, they would have to go after command and control centers, all the logistic bases of the Libyan Air Force. It otherwise wouldn't work. And I think that's a reasonable argument to make. But still, we have to say that there were covert measures to assist the rebels that were not covered, indeed were banned by parts of 1973. Some Gulf states were providing direct military aid. As the campaign emerged and moved on, NATO started to look like it was the tactical air wing of the Libyan rebels. That looked like it went a little beyond the resolution. And so there has been some pushback. We are now suffering from that. So what should be done? With the suffering is now coming out from Russia's and China's refusal to allow resolutions that would go forward that would provide symmetrical pressure on the rebels and on the government in Syria, such that it would hopefully bring them to the negotiating table. Again, my former boss, Kofi Annan, when he came back out of frustration with his mission to try to find a mediated solution, said that he was sent out there totally disarmed, naked, so to speak, to try to deal with these very tough powers. He did not have united support of the Security Council that would send a message to Mr. Assad that negotiations were essential. And without that, the negotiations could go nowhere. What should be done? Let me just mention two things. One is that I think we do need to have another conversation, another SG's report about the circumstances under which R2P should be exercised. I think, like Ambassador Schapper, the three pillars doctrine is a very good approach. We need to refine better the circumstances of the third pillar. When it's used to pressure a regime, when it's used to mediate, when it's used for regime change under some radical extreme circumstances. We need to have a strategic discussion of that. And I think the Security Council needs to take on board the idea that they would set up a subcommittee to help monitor the license that's given of all necessary means so that no one would feel like they're writing a blank check and that it would be interpreted in ways that were unacceptable. That said, this committee cannot micromanage a military operation from New York or anywhere else, but it should be there to monitor and follow up on the implementation of any R2P resolution that goes through. The alternative of not finding a new common ground for R2P, the alternative is what we face today in Syria. That is, we have a stalemate where R2P is not available to assist Brahimi in his mediation. And then we now have the workarounds, that is, states that are beginning to recognize the rebels, and as are some Gulf states, sending them military weapons, and as are many other states, sending them non-lethal weapons. These things go together, it's well known. And so the rebels will be strengthened through these measures. $60 million is fungible. It will be used for all sorts of different, and that's on top of the earlier $70 million. It will be used for all sorts of purposes. This war will continue to escalate. It's not being stopped. The only really effective way, I'm still convinced, as I'm persuaded by Ambassador Schapper and Mr. Brahimi, is a united approach. And the idea being, Mr. Kerry mentioned it this morning in Rome, that this additional assistance to the rebels is not designed to fight the war, but to persuade Mr. Assad that it's really time to come to the negotiating table. And for that to work, we'll need Russia and China and the other members of the Security Council working with their colleagues on a more united approach. So let me stop right there.